Hey everyone, and welcome back to today's video. Today we're heading into civil court to meet a Karen who insists she has rock-solid evidence proving she's being exploited by a debt consolidation company. The only catch? She conveniently left that evidence at home for reasons that remain utterly baffling to me. So let's dive right in.
Case number 25-050805 Credit Union versus Teresa Davis Seals.
All right, appearances for the record, please.
Good morning, Your Honor. Elizabeth Butler, P80956 for Plaintiff by Credit Union.
All right, good morning, Ms. Butler. And ma'am, what is your name?
My name is Teresa Davis Seals.
Okay, and good morning to you as well. Today is the date scheduled for 2 hearings, I see. We have a motion for summary disposition that was filed by the plaintiff. And then I'm looking at a letter which indicates that Ms. Davis Seals is requesting a motion to dismiss the case. So we'll figure out which one we would like to address first, but I'm thinking let's go with the defendant's motion first. Ms. Davis Seals, what's your argument?
Okay, Your Honor, I would like to say that Ms. Butler has no case, and the information that she has compiled in her packet that she does have, it basically has come from me, from the mediation that we had of my receipts. She has no information, and she's now wanting this hearing to further get additional information from me to work against me, which is ridiculous. And I only came to this hearing today just to find out more about Ms. Butler and her affiliation with this credit union, why she's even with them, why is she working for this particular situation. I have no dealings with her and her organization or her company, and I see no reason to even be having this whole case situation to begin with. I tried working with that credit union one-on-one myself. It was not necessary for them to take this route, and now they have put her out here not equipped because she doesn't have any information. They didn't give her any, and now she wants to use me to work against me, which is crazy. This is why she wants this meeting today. She wants to hear additional information, and I purposely left my information at home. I have additional information other than this makeshift packet that she put together, and I purposely didn't bring it because, as I stated, I want to hear more about her affiliation with this company, and to let her know that the information that she does have is inaccurate.
Well, thank you so much for confirming that what she has is inaccurate. Now, would you mind actually proving that with evidence you didn't conveniently leave sitting at home?
Okay. Well, now you've asked me to dismiss the case. And in order to do that, we would have to have a legal basis to do that. And I hear that you're not happy with the fact that she's filed the case. You don't understand who she is. You don't like the fact that she's got information from you that she's using in the case, which, by the way, that's okay. Either side can use information from the other side. As a matter of fact, that's a process that we call discovery. And it is authorized under the Michigan court rules that you can ask each other specific questions about your side of the case or their side of the case, whichever you want. Any factual information, questions can be asked. You can ask for documents. Documents can be provided both ways, from the plaintiff to the defense, if the defense wants to see documents that the plaintiff has, and vice versa. So that part is technically okay. But for you to ask me to dismiss the case, I just can't dismiss the case. I have to have a legal grounds to do that. And I'm not really hearing specific legal grounds, although I am hearing some other things that you're not happy about. So
Your Honor, could I say something else? I just want to bring out all of the rest of my feelings and information and everything concerning this case on September the 25th for the trial. As I stated before, the reason I don't want to keep giving information pertaining to Ms. Butler here is because she has no information and she's trying to use me to build the case.
Ma'am, that's okay. That happens.
You
You
could be talking to them, not me.
Well, let me say this. It's if this case gets to trial, it is their burden to prove the case. But they can do that by any type of information, whether they got it from you, whether they got it from their client, the credit union, whether they got it from answers that were filed to interrogatories or your response to the complaint. That's okay. That's the way a lawsuit progresses. So it's not like she's doing anything wrong, but if she is using information that she obtained from you.
Well, Your Honor, she's not giving me any. When this
Did you ask for any information?
Yes,
Okay.
she didn't even answer her phone when I called.
Last time I checked, there's a very specific, formal process for requesting discovery, and it most certainly does not involve relying on anecdotal, unsubstantiated claims of missed phone calls.
Well, ma'am, let me tell you, there is a written discovery. I don't even know if the court had ordered it before, but if I did, there's written discovery that you can use to actually ask for information. Now, from what I'm seeing here, this got filed fairly quickly, this motion. So I'm not even sure that we even did a scheduling order for discovery yet. They filed their motion for summary disposition, I think, before we even got to any of that. And I'm not even sure if you went, maybe you went to mediation. You did go to mediation. Well, at least it was ordered in July. Let's see if you went. I don't know.
Yes, Your Honor, we did go to
We had mediation.
Okay. So usually after mediation, can somebody tell me the date you went? Because usually that's when we would do a scheduling order.
I think it was August 14.
Okay. So I don't see a scheduling order back yet. This motion got filed though in August.
Your Honor, may I respond to the defendant's motion, or do you even need me to file?
Yeah, well, I'm gonna let you say what you need to say. I just wanted to make sure she was clear on the fact that some of the things she's complaining about are okay. So go ahead and respond, Ms. Butler.
Thank you, Your Honor. I mean, you said that there needs to be a legal basis for a motion to dismiss, and thank you for explaining that my client's entitled to ask for information from her. We attended the mediation, and I had asked her for copies of checks. I wanted to make sure my client had the right balance, that she was giving credit for all of her payments. She kindly provided that, and my client reviewed, and we filed our motion for summary disposition based on the balance, and we included a full accounting of the motion. That's what she had wanted to see, and she was served with a copy of the motion. I'm happy to—
Let me interrupt you a minute. I'm looking on my electronic filing and I see the motion itself, but I don't see, let me see if there's a brief. I was looking for the brief and I couldn't find it.
We filed a brief with exhibits and proof of service and a notice.
Okay, let's see. I do see something that says exhibits, so let me see if that's it. Yes, you're right. Says exhibits, but there's the motion. Okay, there's the, well, no, here's the exhibits. Okay, let's see if I got a brief with it. Okay, I've got all of the exhibits that you've attached right here. And it just says exhibits, but there's no motion. Let's see, notice of hearing and there's no brief. I've got the motion, which is just your standard motion, but I don't have the argument. Do you know what date that you filed the brief?
On August 18th, the same day we filed the motion and those exhibits.
Okay.
Yeah,
So
filed
let
stamped
me
copy.
let me look at everything from August 18th. So here's the motion. And the motion does not have anything else attached to it. It's just got a motion. And it appears to be about 2 pages. Then there's a notice of hearing from the 18th also. And that's 1 page with a date to be determined by the court. There's a proof of service from the 18th, which says everything was served on August the 18th. That's also just 1 page. Then on the 18th, here is a proposed order. That's 1 page. Then the next document. Aha! There it is. I must have missed it before. Here's the brief.
No problem, Your Honor.
Okay. All right, go ahead with that, your argument then. You've got your documents attached. I see those.
Yes, Your Honor. This relates to a loan that Ms. Davis Seals took out with my client, the credit union. She seems to be under a misunderstanding that my office owns the debt. We're just the lawyers to provide credit union. They still own the debt. We're not a separate debt buyer in any way. We're just humble attorneys.
Yeah, you're just representing the credit union.
Correct.
Mm-hmm.
Ms. Davis Seals had a loan before this loan that's the basis of the lawsuit. The loan that's the basis of this lawsuit was a debt consolidation loan, where she was given a new loan. So Ms. Davis Seals had made payments on that prior loan, and my understanding is that she's concerned she didn't get credit for those prior payments. I think what she's not understanding is that this was a new loan, and the payments made before don't apply to the new loan. The new loan encompassed all her prior payments and what she'd owed before. After mediation, she kindly provided my office with copies of her receipts. I had my client double check everything to make sure that all her payments were credited. She had admitted that she missed some payments, which is the basis of the default on the loan. Attached to the motion for summary is a full accounting of all her payments and also an affidavit of account from my client confirming the balance. That was the basis for the motion for summary. She doesn't seem to be contesting that she took out the loan, that she owes money. She just was worried about the payments, thus the full accounting affidavit of the balance. I'll also point out she hasn't filed a response to the motion. Maybe if you want to consider her letter a response to the motion, she still has not presented any genuine issues of material fact that would justify a trial, nor has she stated any valid defenses. This motion's under 2.116, C9 and C10. If she doesn't present anything that would contest this balance, there really isn't much more for the court to review based on what we've already provided. That's why we ask that this court consider denying Ms. Davis Seals' motion to dismiss and granting this motion for summary disposition. Again, there's really nothing to review further at a trial.
There would have absolutely been something else to review had this individual actually brought it with her instead of deliberately leaving at home. That was an exceptionally poor decision. Karen.
All right, thank you so much. Okay, so Ms. Davis Seals, I'm going to give you a chance to respond, but the gist of her argument is that, number one, she's just the lawyer for the credit union. She's not trying to collect the debt for any other entity other than the credit union. And that's how she's involved in the case. Number two, she indicated that at the mediation, she got your documents to make sure that you were credited for any payments that you had previously stated that you made, and that there was a prior loan, and then you got this new loan for debt consolidation. And they verified that all of your prior payments were indeed credited to the other loan. And this is a new loan, and that you've admitted that you pretty much owe this loan. There's no question there that you owe that debt. You had missed a couple payments, so that's the default. And otherwise, she says she's checked her balances, and this is the correct amount that's due, so that there really is no issue to go to trial on. And if there's no issue to go to trial on, we could enter judgment for the credit union today because there's no issue. A trial is held when there are actual issues that we're not sure, well, what's the facts? This
Okay,
case, she argues these are the facts. No one's disputing the facts.
I'm
So-
confused. Your Honor, let me speak on each one of those issues you just mentioned. Number one, this is a debt collection agency that's working for them. They have bought out this account from this credit
Ma'am, there's
union.
no evidence of that.
That they have. The paperwork that
excuse
wait, let me finish
me.
talking. Your
I
Honor.
need you to, I have to be based in reality here. So I need you to show me what documents you have that support the fact that they bought the debt and that they're actually the people collecting it, because the lawsuit is not in the name of the law firm. And it's okay for a debt collection law firm to represent the credit union because the credit union is trying to collect a debt. And they typically do hire debt collection firms to do that. So
Okay,
you
Your
have
Honor,
to-
let me
ma'am,
finish it. Let me finish.
Ma'am, you can't say that to the judge.
listen,
okay,
I'm sorry. I'm sorry.
Okay,
I'm not there.
okay.
And I'm not going to try to overtalk you.
Okay, I'm sorry, Your Honor.
And I'm the one that knows what's going on. I understand the law and I understand this process. And I've looked at these documents and I'm trying to explain it to you. But if you want to overtalk me, that's not going to work. Now, I'm fully happy to listen to anything you have to say. That I am willing to do. But if it's not right, I'm going to have to tell you that. And we got to move forward from
I
there.
understand.
Okay, go ahead.
Okay, so here's the whole situation. I took out the loan and I did that. It was a double loan. I started with one. They merged that first one in with the second one. It became a combined one loan.
Welcome to the world of debt consolidation, essentially a polished way of saying, pay me all the interest you would have paid them anyway. On the surface, consolidating all your debt into a single lower interest loan sounds remarkably appealing. But in reality, these companies often impose exorbitant fees and steep interest hikes the moment you're late or miss a payment, which is exactly the predicament the defendant finds herself in today.
Out of that one loan, I have paid over $8,000 and plus for that whole loan. It became a consolidated one loan. And they are not accurately giving me the credit for the amount that I have paid.
Okay, ma'am. Well, you're going to have some documentation to show
I
me.
have it. It's at home. Like I said, I didn't bring anything.
Today was the date to bring it. We don't get to trial when there's a motion pending. And in order to actually respond to the motion, you needed to have brought your information today.
It was my understanding this was just a hearing before the trial.
It is a hearing before the trial, and it could end up that you don't get to trial if her position is substantiated.
Well, it's not accurate. They have false information regarding what I have paid, and everything else that she's saying about this, what they have done is false and against what is actually true.
Okay,
and
ma'am.
I wanted to bring out all of my information
You don't have
during
it.
the trial. That's what I thought I could do.
We don't get there. This is the date to do that. This is a motion for summary disposition. That means this is the date where the case could be totally dismissed and we don't get to trial based upon their motion. This was the date for you to file a response, like she said, which you did not do, but that's okay. If you had brought some information today, we could have dealt with it orally to some degree. But if you don't have anything, I can't just go on your word that they did something false.
I have it
I
at
gotta
home.
have documents. Ma'am, you were supposed to, I don't know why you would come to a court hearing without the
Because
proper
I thought this was just a hearing, that we were just supposed to voice. It was I thought it was similar to that orientation we had, which, by the way, she started with one sheet of information. Then all of a sudden, after I submit my receipts, she comes with a bogus packet, of which over 99% of this packet is incorrect. And this is why I thought this was just another hearing to voice why it should go, like you said, go any further or not, because none of what she has in this packet is correct.
And
they
I have no evidence to show that none of what she has in
And
the
I'm
packet
sorry, I made the mistake and left it at home. It's at home. I have the information to show it.
Well, if you have evidence, but it's at home while you're at court, then you have nothing.
And they have it. They have the accurate records of how much I have paid, but not giving me credit for it. I do not owe the amount that they're saying, and I should not be assessed anything any different. This is a collection agency that has gotten that account. They want to take it over and want me to start from a whole big balance amount, of which is not true. I have paid this credit union over $8,000, $8,231.07. And they are not giving me the credit for it. And then they want to continue on with a huge balance. How can you come with a balance of 11,000 plus when both of the borrowed amounts were 7,000 each, and I have paid over $8,000 plus?
I don't know.
$3,500 left.
You have to look at the terms of your loan agreement. I'm sure there's interest and penalties on late payments that apply.
And that's another, I'm glad you mentioned that, Judge. And what she said earlier about missing some payments, I've never missed. I've been late, and I admit that, but the late ones I have gone up with and moved forward. There's no way I could reach $8,000 plus not paid. I have paid late. I've never missed. So that's an incorrect statement that she has made. This credit union is crooked and biased, and is sorry for that she's representing them on those premises, but that information that she has given is incorrect. And like I said, I didn't understand. I thought I could bring my information to the court. I thought we would be having a case on the 25th of September. And so my information is valid, but it is at home, because I thought she was trying to continue to get more information from me to base her case.
Now, if you had read the motion, it says in the body of the motion that she's asking the court to enter a judgment against you today at this hearing. That's what the motion says. It doesn't say she's trying to get any information from you. It says she's looking for a judgment. And if she gets a judgment, that's the end of the case. There is no trial.
Well, Your Honor, I would still like to request the trial to go through for the 25th.
I can't do that, ma'am.
Allow
I
me
have
to
to
do-
resolve the motion today. I can't do that. That's why she filed the motion.
It's inaccurate, and it was not my clarity. I had a lawyer through the Lakeshore situation, and they completely just dropped me mid-screen, no assistance. And when I came back in, they later came out here. They came to the court and were meeting people downstairs. I asked why was I dropped. They could not give me a valid. Only thing the lady said was, well, we're short-staffed. But yet they had started in the middle of my situation. It's unfair to me to have taken on this type of a situation by myself. I had my legal help that I thought I had snatched completely from under me for no real valid reason. They had already started. So to tell me that they were short or they have a lot of people, that was an injustice to me, because they had already started the system.
Well, if you claim to have evidence, but it's sitting at home while you're standing in court, then for all practical purposes, you have absolutely nothing